Next, we will go on to the lecture 2, relationship between the office and appeal department. We will have the 3 lectures again to do the presentation. And the first starter is the Director General Kyoko Tamura of Trial and Appeal Department of Japan Patent Office. Now, I would like to talk about the relationship between JPO Trial and Appeal Department and courts. There are 3 themes. 1. Double track system. 2. Information exchange between JPO and courts. And 3. Personnel exchange. Please go on to page 3. As shown in the diagram on the bottom of page 3, I'm sure you know this. Once a patent is registered, the patentee can file an infringement lawsuit based on the patent rights in the Tokyo or Osaka District Court. The defendant in an infringement suit or alleged infringer may challenge the validity of the patent as a defense to invalidation in the infringement suit. And at the same time, the defendant may file a request for a trial for invalidation with the JPO. Please go on to page 4. As I mentioned, for determining the validity of a patent, there are 2 routes. Trial for invalidation route, which goes through the JPO, and 2. Infringement lawsuit route, which is conducted in courts. We have so-called double track. The difference between the 2, as shown in the blue text, is that trials for invalidation are conducted ex officio, and their decisions have binding legal effectiveness as to third parties. Infringement lawsuit proceedings are conducted by adversarial system, and their decisions have relative effect. As shown in the middle figure, in a typical double tracking, infringement lawsuits are filed earlier, followed by requests for invalidation trials. As shown in the right, 60% of the infringement lawsuit is simultaneously pending the invalidation trials for the corresponding patent rights. And, well, in the bottom square regarding a trial for invalidation route, which an infringement lawsuit is pending simultaneously, JPO gives the highest priority and renders trial decision early. So such decisions can be referred to parties and courts. Thereby, JPO can contribute to dispute resolution because JPO is a professional regarding the judgment in the technical field. We consider this is a responsibility of JPO. Please go on to page 5. This shows the analysis of such double track system. So you can find the bar chart between conclusion of JPO trial decision and district court decisions. Concordance rate of determinations on invalidity is high. It is 81%. The total of dark blue and light blue portion of the pie chart. The analysis of cases with differing conclusion is shown in the small pie chart. Of the cases where JPO trial decisions and district court decisions differed, the rate of IP High Court decisions reversing JPO trial decision was 13%. Therefore, I believe that concordance rate of determinations between court and JPO is high. Page 6 shows the order of determinations by JPO and courts. In most cases, lawsuits are instituted before, but as shown in the pie chart, in 68% of the cases shown in orange, the JPO rendered its trial decisions first. Also, as shown in the bar graph on the leftmost side, cases in which an invalidation trial was filed more than 360 days or 1 year after the lawsuit was filed. In nearly half of 45% in orange, JPO rendered its trials decisions first. As you saw on the previous page, determinations between JPO and courts enjoy high concordance rate. So, if we strive to render trials decisions earlier than those of court, we believe that will contribute to users. Therefore, we will make every effort to improve quality and speed of trial decisions. Page 8 is the information exchange between JPO and courts. A proceeding relationship between trials and, you can see the photo with the cherry blossoms during the spring. A proceeding relationship between trials and lawsuits is governed by Patent Act Article 168. There are two purposes of having this Article 168. One, by obtaining information on the institution of infringement lawsuits, the JPO will aim for early conclusion of the proceedings in trials for invalidation for the corresponding patent right. We can speed up the examinations and trials. And two, in cases where an infringement lawsuit and an invalidation trial are concurrently pending, the JPO should be aware of this in the ex officio proceedings in the trial and proceed while considering the relationship between the two procedures, thereby preventing discrepancies in determinations between the two procedures as much as possible. And so when there is some kind of evidence, using the ex officio proceedings, we can avoid the gap of the judgment between the two organizations. Please go on to page 9. It shows the specific procedures of Article 168. First, the court share information with JPO that an infringement lawsuit has been instituted. Upon receiving the notification, the JPO shares information with the court on whether a request for a trial has been filed. In the case of an infringement lawsuit in which an invalidation trial is simultaneously pending, when invalidity defense is raised, the court will share such information with JPO. And 4, in cases where an invalidity defense is raised, if needed, JPO can request for sending copies of any record of the infringement lawsuit. Page 10 is the text of Article 168 itself. As shown in the reference below, there are similar to mutatis mutandis provision applied to Utility Model Act, Design Act, and Trademark Act. In this way, regarding double-track cases, to contribute to expeditious dispute resolution, the JPO is giving priority to the early conclusion of the proceedings. When time permits, we strive to make appropriate decisions by considering evidence submitted in invalidity defense in infringement litigation. Last topic is personnel exchange. Please see page 12. The left side shows the process of developing administrative judge of JPO. In the dark orange area on the bottom, you can find administrative judge and chief administrative judge. They have been with the JPO for about 20 years and more and have a lot of experiences in examinations and trials. They sometimes seconded as judicial research officials and support judges with technical knowledge. So, look at the small chart. Regarding judicial research officials, there are 11 at IP High Court, 7 at Tokyo District Court, and 5 at Osaka District Court, totaling 21. Of that, 19 are seconded from JPO, and 2 are from Patent Attorney's Office. They usually serve 3 years as judicial research officials, and based on such experience, they continue to play an active role as high-quality administrative judges. Page 13. As described in page 13, judicial research officials are full-time employees of the court. Duties are provided in the Code of Civil Procedure, Article 92-8. And page 14 is about the main duties of judicial research officials. And the 4 is the main one. Based on their technical knowledge, they state opinions about the case to a judge. Also, they ask questions of the parties or urge them to offer proof on the date for oral arguments or argument preparation, as described in 1. Number 3, giving an explanation based on expert knowledge on a date for attempting to arrange a settlement. So I talked about double-track system, information exchange, personnel exchange to explain about the relationship between JPO and the court. We will continue to utilize each other's system and human resources and share necessary information. We will make every effort to resolve dispute as soon as possible. This concludes my explanation. Thank you very much.
Judge Tamura, thank you for your presentation.